And today's presenters, Jessica Mead, attorney at law, Collins plus Collins, and April Mitchell, attorney at law, Collins plus Collins. And I misspelled the first Collins. Bad me. I just want to say to everyone that's here, I have been presenting at conferences with Collins and Collins since the late 90s. Sam Muir and I used to do a lot. And I really enjoy the firm. It's such a wonderful firm. So I just want to say that because I've been with you guys for a long time and actually having some fun. So I'm going to
Thanks,
turn it
Jeff.
over to April and Jessica to go ahead and start the presentation.
All right, let's see my screen sharing skills. Um, all right, so as Jeff introduced us, I'm Jessica Mead, and I'm presenting with April Mitchell, and we are attorneys with the law firm Collins and Collins. Firm's been around for decades, and we specialize in representing design professionals. So today we're going to be going through tariffs and AI. And as architects, you know that these external forces are really going to be impacting your area of practice in the upcoming years. So let me give you a brief overview of what we're going to be going over today. We're going to be exploring how tariffs and AI are reshaping the architectural landscape and how they can expose you to new risks, and importantly, what you can do to protect yourself from these risks. So we'll be talking about the impact of tariffs on your practice and exposure to new claims, strategies you can use to mitigate some tariff-related risks, AI, different ways that it is being used in architecture today, as well as how its use is going to impact the professional standard of care. And finally, we're going to end with some policies that you can consider to make sure that your use of AI is responsible and going to protect you from types of claims that we can expect to start to see. Before we get into it, I do want to note that even though April and I are both lawyers, nothing that we say should be construed as legal advice. And if you have any questions, please feel free to reach out to either of us. So today, as I mentioned, we're going to discuss the impact of tariffs on specifically material selection, budget, and schedules, and how that can impact your practice and the types of claims that you can expect to see. Our goal is for you to understand what you can do to reduce your exposure to these kinds of claims, as well as help you recognize how AI is going to impact the professional standard of care and consider AI policies that will promote your professional responsibility and protect your area of practice. So we're going to start with tariffs. Even before this past Friday, this administration's tariffs have been one of the most significant changes in global trade in decades. And companies have had to scramble to figure out changes to their supply chains to determine how they can address tariff-related risks. And when we're speaking about tariffs today, I do want to break it into two categories. So first, we have the worldwide product-specific tariffs, and these include things like the 50% tariff on aluminum imports into the U.S., 50% tariff on copper and copper derivatives, and the 10% tariff on lumber and timber. And the increase in tariffs, or the increase in costs due to tariffs on these materials, is what's really going to directly impact budgets and schedules in current and future projects. In addition to these product-specific tariffs, up until this past Friday, there were also country-specific tariffs where the amount of tariff on an imported good depended on the country of origin. So in addition to causing price increases, tariffs also create a great deal of economic uncertainty as we're entering this more volatile and unknown economic environment. So just this past Friday, the Supreme Court ruled that many of the tariffs that the president had imposed were unconstitutional and struck them down. And these were tariffs that were specifically passed under the International Emergency Economic Powers Act. And so these were the tariffs that were country dependent. And so this Supreme Court ruling has really created a situation where trade deals that were made based on now illegal tariffs are up in the air. The ruling also left the refund issue undecided, and it doesn't specifically address whether companies are entitled to refunds paid in tariffs that were imposed under that statute. And there's also an open question on whether or not companies that raised their prices in order to account for the tariffs will even have standing to pursue a refund. But the bottom line is there's not going to be a lot of certainty on this refund issue, and the process will likely take years to months to be set up. In response to the Supreme Court's ruling, the administration used Section 122 of the Trade Act to impose just a flat rate 10% tariff on all imports from all countries for 150 days. So while the president initially indicated that these tariffs would actually be at 15%, which is the maximum amount allowed under that statute, so far it's still just been at the 10% rate. These tariffs are set to expire on July 24th, 2026, unless extended by Congress, which at this point seems unlikely. There's a chance that there will be legal challenges to the use of Section 122 to impose these tariffs. But since it's such a short time that they're going to be in place, it's likely that they'll expire before the issue of whether or not it's constitutional is heard. In addition to Section 122, we likely will see other ways that the administration seeks to pursue tariffs under other statutes and routes. So bottom line is we're really in a period of uncertainty in terms of global tariffs, but the Supreme Court ruling does not impact any of the product-specific tariffs that we discussed having to do with steel, aluminum, lumber, timber. Tariffs are going to continue to impact businesses and consumers. The longer that they're in place, the likelihood is that prices are going to have to continue to increase and be passed on to consumers. Architects in particular are going to experience the impact of tariffs in terms of budget concerns that can result in design changes, rising costs, especially for imported steel, could force redesign and tighter budgets to account for the increased material costs. There's also a chance that we're going to start to see supply chain disruption, especially with the increased uncertainty. Materials could require longer lead times, which makes it difficult to source materials, and that can cause project delays, which will make it difficult to predict project schedules. In terms of alternate materials, architects may be required to start looking at alternate domestic materials that might not be consistent with original design intent. There's also a chance that the continued presence of tariffs will create a shift in the types of projects that we're seeing. This realm of rising material costs and uncertainty creates potential for reduced demand for new large-scale construction projects and more of a focus on either renovation or smaller scale projects. Architects can try to manage some of the tariff-related impact proactively by looking at prefabricated solutions or incorporate modular design to mitigate some of this tariff-related risk. And architects can also seek for more and more opportunities for early collaboration with contractors in the design phase so that contractors can try to get a head start on sourcing and stockpiling materials to try to reduce some of the supply chain disruption or increased project costs. In addition to impacting the architectural practice generally, tariffs are also likely going to impact the types of professional liability claims that we're seeing. So in this realm of increased risk and uncertainty, that's going to create pressure where there's an increased likelihood in disputes over project scope, timeliness, and deliverables. There's an increased potential for professional liability and breach of contract claims when projects aren't built and owners and contractors are looking for ways to recoup some of their tariff-related costs by looking for something that they can point to in the plans as a basis to explain why the project wasn't built. In terms of cost overruns, the tariff-related increased project costs can create claims for cost overruns and budget mismanagement, especially when the architect's involved in pre-construction and cost estimating services. And as I mentioned, there's a greater chance for project delays based on material shortages and increase in costs, as well as the need for redesign to accommodate the increase in costs. These delays can also result in breach of contract and professional liability claims for failure to consider tariff-related increased costs on the design and the schedule, especially where the architect's scope of work includes project scheduling estimates. The tariffs also raise potential new regulatory compliance claims. The changes in the materials that may need to be used on projects could result in a situation where local materials need to be sourced that don't comply with local building codes or environmental regulations. And if those are not accounted for, that could result in subsequent legal claims as well as penalties. And then finally, just the financial strain from the increased cost and project delays raises the potential for insolvency of the owner or contractor, which in turn could result in unpaid work. Now that I've gone over some of the risks that tariffs raise, April's going to go over some strategies for mitigating these tariff-related risks.
All right. Thank you, Jessica. So the easiest, cleanest, simplest, absolutely least surprising mechanism to mitigate some of these risks is through your contractual provisions and in the contracts that you enter into every day. Clear scope of work and exclusions. Really, on any project, you want to make sure that your contractual duty and obligations are consistent with what is actually within your control. So you want to now more than ever take care to ensure that every provision within your scope in your contract defines your scope as things that you can control, that are within, your abilities and not beyond the things that you can promise. The best way to avoid tariff-related impacts is to explicitly exclude budget, cost estimating, and schedule preparation from your scope of work. I know that's not always feasible, and for a lot of you, that's quite frankly something that the owners and your clients hire you for and insist that be included in your scope. So to the extent it's unavoidable to exclude things like budget, cost estimating, and schedule preparation from your scope, it is best to include very clear provisions that the architect is not responsible for increases and delays due to tariff-related impacts. And to the extent you are able to get some of these provisions within your contracts, excluding it from your scope. Another point to be wary of is what we refer to as scope creep, where you collaborate and contribute and you work together on scheduling and budget and contract needs. But it needs to be made clear that you are not responsible and that you are cognizant and careful of not becoming so involved with providing the cost estimates and the input on something that you don't assume a duty that it was in your scope. There's also price escalation, material cost adjustment clauses. These are something to be very, very wary of, but very, very cognizant of when they do exist. While not as common within your contracts and not applicable directly to your contract with the owner, it's important to be aware of these clauses because they will likely become more and more common as the tariff-related uncertainty persists. What these provisions are is they allow the contractor to shift the risk of a price increase onto the owner or any higher tier contractor if there are sharp price increases in materials or labor during the contractual period. Usually these are tied to the material price index and typically permit the contractor to recover all or a portion of the price increase that is above a certain negotiated threshold. So typically, for example, 10% rise in the index, that would trigger that provision. And very frequently we see other contracts, whether it be the owner and contractor or another higher tiered contractor, incorporated into the architectural contract. So it's very important to be aware of those provisions when they do exist and to tailor your contract accordingly. The force majeure provisions, I actually had a client today say, oh, we're fine on that. We have the acts of God provision. So just so everybody's aware, a force majeure clause allows parties to change certain contractual obligations if an event is beyond the party's control. And that typically includes, wars, strikes, pandemics, things of that nature. Whereas an act of God is exclusively a natural force. So earthquakes, floods, hurricanes, things of that nature. So typically, acts of God provisions have been more prominent in contracts. And those would not include a force majeure instance, such as tariffs and tax-related issues, whereas a force majeure clause may include an act of God. So with that backdrop, the force majeure provisions themselves do not necessarily cover the tariffs or the material shortages and price increases due to tariffs. So you want to tailor it to explicitly enumerate the trade restrictions and government regulations as covered events. The clause needs to define when government actions rise to the level of prevention of unreasonable delay versus a mere cost increase, which is not going to be covered by a force majeure provision. Price escalation and force majeure clauses are not as applicable to architectural agreements as they are to the contractors agreement, but the main thing to keep in mind is that you want to have clear language along the lines of the architect is not responsible for price increases, delays due to tariffs and or any other cause outside of the architect's control. Limitation of liability clauses, and I'm also going to add into that consequential damages provisions within your contract. Those are also great mechanisms in any contract, but more specifically as it relates to these tariff issues, you can tie these directly to the increase in the tariffs. You can a consequential damages waiver in and of itself will not likely include tariffs and cost escalations and price increases unless it's included. So if you can get in there that it is explicitly, owner waives any and all consequential damages, including but not limited to, and then have that language specific and tailored to to the tariff provisions. The clauses should distinguish between direct damages that the architect may bear some responsibility for, and the consequential economic loss. That's because they're not going to apply to professional negligence claims or claims asserted against an architect by an individual who is not a party to the contract. Change order procedures for the scope modification. This is very, very important for many reasons, but specifically as we're seeing things such as, product delay, material changes, ad services. One of the biggest impacts of tariffs on architects will likely be the redesign requests as materials change, the costs rise, and the financial conditions shift. So for that reason, it is very, very important to have very clear provisions detailing when and how you will get paid for redesign work. And tied in with that is, again, having very clear and specific scopes identified within your contract, and when things are going to be added. How is that? What's the process for that? How will that be submitted? What is the timeline to pay that? Is there an approval requirement? And any sort of change needs to be very specifically outlined. And the process to follow should be very clear so that you know what you need to do to be able to get paid for additional services that are going to be required because of these tariffs. And these clauses do need to establish clear thresholds for triggering the additional compensation, documentation that's required, and create a streamlined process for the cost adjustments. And one thing to note is that this also can be done with milestones. So, for example, once the owner approves, say, the schematic design, then they cannot go back and change the schematic design. Same thing applies for the design development, construction document phase. If you put those milestones on it, it prevents them from being able to go back and modifying those and requesting redesign without any additional compensation. Another mechanism is to limit the number of meetings that is included as a basic service and explicitly state that further meetings will be billed as an additional service. As you all know, increased work will require increased visits, increased inspections, things of that nature. So one way to ensure that you get compensated for any additional services that you provide as a result of any tariff-related issues, cost escalation, price increases, anything of that nature, is to put a specific number on everything, saying once this figure has been met, anything else beyond this is an ad service. So communication is also very, very important, of course. While specific tariff on given materials is in flux, let everybody know, be aware of the potential impact of change in tariff policy. And let everyone on the project know that you want to be proactive and clear in communicating risk of the tariffs on the project budget and the timeline. The more that you say, hey, this could be an issue down the line, or hey, we need to address this, you are providing notice. You're giving everybody an opportunity to mitigate their own damages, and to resolve things early before the issue can become very costly and time consuming. So notifying and communicating and being proactive can be really, really crucial to helping mitigate any of your exposure for the tariff increases. Identify the issues and the potential need to increase the contingencies. So that's, again, identify what the specific issue is, as well as, hey, this is going to be the potential impact on this. We're going to have a budget bust. We're going to need to increase the contingency draw, or we're going to need to reassess our timeline. We're going to need to see if there's another way that we can that we can mitigate the impact of these delays, these increases. I think Jessica said earlier, if you could stockpile materials, if you can plan ahead in any way, that will help significantly to reduce any sort of disruption and or delays. And early collaboration with everybody is, not to belittle the point here, but that's, the earlier that you can notify everybody, you will be in such a better position to the extent there's issues down the road. To be the one to say, hey, here is the problem now, we should address it now, is going to be significant. And document. I know all of you here, us, AIA, everyone's always preaching that. And especially these days with AI, as we'll get to later, it is more important now than ever to document everything that is being said, all of the notice that you're giving everybody. Even as I mentioned a moment ago, when you have an ad service, when you're submitting your invoices for redesign, all of those things, document and have that set forth so that you can point to all of the points where you said, here is the support, here is the basis for this, and here is what we're submitting on this behalf. So another point is to leverage data and technology, monitor market trends. I know a lot of people think, I can't watch the news. I can't deal with any more anything else going on in the world. And that's fine, but we need to be aware of what is going on and how it's going to impact your project. The tariffs are typically imposed with notice, in that we have been seeing them being announced as far as, if X country doesn't comply with this, we are going to impose tariffs of X by X date. That's all you need to be aware of then is, okay, what is the potential impact and how is it going to impact my project in this situation? Consider design techniques that will cut down on overall steel and lumber use. As also mentioned earlier, maybe consider reusing and salvaging on-site materials. Leverage technology to promote efficiency. There's many resources and tools available to you that you can utilize to see if there are ways that you can stay on schedule. Is there a substitution that you can use that won't impact the overall design and or the project? The critical path. So use the resources available to you to promote efficiency and stay on schedule. And on that note, we will talk about some of that, some of the technology available to you these days and the impact of that.
Yeah, thanks, April. That's a nice segue into artificial intelligence, which is our second topic today, and certainly a technology that you can use that will help improve efficiency and potentially help keep you on track, even when there's external factors that are slowing down the schedule. There's hundreds of AI programs out there right now in the A&E world. And the way that the AI is being used really depends on the phase of design that it's being used in. And I'm sure, just like lawyers, designers are getting heavily marketed by these upstart AI companies. And one of the challenges right now is really being able to tell the difference between what's a valuable product versus what's something that has less sophisticated technology. As these programs start to get more widely used and vetted, the number of programs will likely kind of start to fall down, and you'll get a better sense of what programs other people are using. But for now, there are a number of different AI programs that can be used for things like site analysis that will process geographical data, to perform sun and wind studies, shadow analysis, and sun hours calculations that otherwise would have taken a long time for data compilation that can happen in just a matter of minutes. And then these AI-generated site analysis can then be used to inform design decisions. AI can also be used to draft contracts and proposals, or there are some AI programs that you can train the program, tell it what kind of things to look for, and you can use it to do contract review. And surprisingly, some of these AI programs, especially as they've like learned you've taught it how to do the review, can be surprisingly accurate and bring up good points without prompting. AI is also helpful in terms of generative design. There's a number of different options for initial design explorations where you can specify land size and building dimensions. And then AI can produce hundreds to thousands of design options within minutes, ranging from 2D floor plans to 3D models. There are programs where you can input keywords, and then AI will produce diverse visuals that you can use for design inspiration, as well as programs that you can input specific criteria, and then it'll generate optimized solutions that you can choose from. As I kind of mentioned with contract review, there are AI tools that can learn your habits and that you can apply things that it learned from prior projects and prior work to future work, which is then where it really is able to improve efficiency. That said, with all these potential uses, at this point, probably the most common use of AI is still for note-taking and recording meeting minutes. But one program that I recently learned about and I do want to go over, partly because it has a fun name, is Google's image generator, Nano Banana Pro. This program's not specific to architecture, but it can be used by architects to really enhance your practice in almost every phase of the design. So starting from master planning, you can take a Google satellite image and have the Nano Banana Pro convert it into a 3D site diagram. And you can control the way that you want the style of the 3D site diagram to look by giving it examples of stylistically how you want it to look. It can also do site analysis. You can feed it coordinates of whatever location you want your building to be in, and it can create a mood board showing different colors and textures of the surrounding building so you can get a sense of how your design would fit into that area. For concept design, if you're somebody that likes to do a bubble diagram, you can just upload that straight into the Nano Banana Pro, and then it'll convert your bubble diagram into a floor plan. And again, if you have a sample style that you like, you can just upload that as a sample style for it to use and copy. Usually, the image generation happens in seconds, but it's not going to look exactly how you want it to look the first time. So it is important that you, continue to work with it. It's not absolute immediate. But for design development, there's also some really amazing features where you can upload a sketch of a building and then have it convert in seconds your sketch directly into a realistic looking photograph of a building. And then you can use that sketch to try out and test different facades. So I'm not somebody that is, particularly good at tech or, I haven't used a lot of AI, but when I first heard of this program, I just tried the free trial on my phone, took a picture of my building from the parking garage and uploaded it. And in seconds, like I just asked it to change the facade to stone and then to glass. And it keeps everything else about the building and the image identical. And you can just test different facades immediately. So that said, if you're intimidated by the idea of messing around with AI because you don't have any experience with it, you shouldn't let that kind of stop you from trying it, because some of these programs are very user friendly and you can pick it up pretty much immediately. Another way that AI is being used is permitting. So Lancaster actually entered a public-private partnership with the AI company Labyrinth to do contractor side AI permitting and speed up the permit review process. So the city is going to use this AI program to pre-screen submissions, validate them against requirements, and flag missing components. And this wasn't like a software that the city just purchased. According to the mayor of Lancaster, they worked closely with Labyrinth for a year to develop a AI program that's specific to California regulatory requirements, as well as the community development needs of Lancaster. And that's another thing that some bigger companies are doing, is building individualized AI programs that they're feeding with their own company specific work. When you read about AI and its potential to revolutionize the way that we do things across all industries, there is a real fear of job replacement. But the data shows that, at least at this point, that fear may be overblown, because even with larger companies, AI adoption remains pretty low. We're certainly not in the place of AI replacing jobs the way that we may have initially anticipated when AI first started showing up in the news. There is, of course, the potential for that to change, and AI adoption likely will change as the technology continues to improve. But it's really going to be important to know, and is kind of the big theme with the use of AI and architectural practice, is even as AI adoption increases and is used to improve efficiency, it's not a substitute for professional judgment. AI is not an architect. It's just a tool that can be used to enhance your work and save time. Like I said, AI tools are susceptible to errors and they require direction and editing. So while they're helpful tools for you to be able to visualize your ideas and show your ideas and can just make the processes faster, they don't have the skill or precision of a licensed architect. So when we think about AI in terms of exposure and the role that it's going to play in evolving the standard of care, we have to think about how AI is going to be used in conjunction with professional judgment. And with that, April is going to go over the professional standard of care.
So as Jessica mentioned, the biggest impact of AI to the design profession is what will be the impact on the professional standard of care. For those of you that are unfamiliar, the standard of care is what your work is evaluated against in the event of a lawsuit. So on the screen, you have KC 600. This is the actual jury instruction that if you are sued for professional negligence, that the jury will be instructed on in finding whether or not you were negligent. And the standard of care is that a design professional is negligent if he, she, or non-binary pronoun fails to use the skill and care that a reasonably careful design professional in the same field would have used in similar circumstances. So the professional standard of care applicable to architects is determined by what other architects are doing in similar circumstances. So as you can imagine, AI has a huge impact on that, because the ultimate question is going to be, are reasonable architects using AI in that sense? And if not, should they have been? So KC 602 states that a design professional is not necessarily negligent just because their efforts were unsuccessful or an error was made. Your services as a whole have to fall below the standard of care. This reiterates that negligence is determined by what reasonably careful design professionals would have done in a similar circumstances. So you determine if the architect was negligent by looking at what somebody else would have, a similarly situated architect would have done in that similar situation. So in order to file a lawsuit for professional negligence, the attorney must first obtain what we refer to as a certificate of merit. And what this requires is that the attorney must consult with a licensed architect to determine if there is good cause for the claim. Essentially, what that means is, does another licensed professional state that the services fell below the standard of care? While I do think there were good intentions when the bill was initially enacted, I think it has gone a little far, and now it has become, anybody. The sole requirement is that it has to be a licensed professional within the same discipline. It's not limited to the state of California. So, for example, if you have a project governed by OSHPD or HCI, whatever it is now, or the California Coastal Commission, something of that sense, the design professional does not need to be familiar with any of those nuances, and or does not need to be licensed within the state of California, as the current state of the law is, to give an opinion that would substantiate a certificate of merit pursuant to the Code of Civil Procedure. So the jury instructions, as well as the certificate of merit process, underscore the importance of what other licensed design professionals are doing in establishing what the standard of care is for architecture. So the professional standard of care is determined by what reasonably careful professionals are doing under similar circumstances. And the standard of care evolves over time, and what met the standard of care 100, 50, 25, even this day and age with AI 5, 10 years ago, may not meet the standard of care today. And a large part of that is due to the technological advances that we're seeing. And I know that there tends to be two schools of thought as it relates to the incorporation of AI into the practice of architecture, one of which is absolutely not. I am so resistant. And then the alternative is embracing it with full arms, or open arms, and just fully really adopting the use of it. And for those that feel they're more terrified of it, you've actually seen these progressions in the past. In the field of architecture and engineering, we've seen modifications and advances with CAD introduction and with BIM adoption. So these systems have been incorporated and have become something that design professionals have come to rely on, and actually really it has made their practice much more efficient. So as daunting as it can be, the the task has been survived in the past.
So consistent with the Goldman Sachs finding that there hasn't been widespread adoption of AI programs by companies, a March 2025 study by the AIA found that only 8% of architecture firms reported incorporating AI into their practice. At that point, only 20% of firms reported that they were in the process of implementation, and 35% were considering adoption. So, now almost a year later, those numbers may have changed, but at least as of last year, the primary use of AI was things like chat box, grammar text analysis, or transcribing meetings, as opposed to more design-specific tasks. And I'm sure, as you can imagine, the study also found that those who did use image generators for their work and did more AI for design-specific functions was younger professionals who were using it for concept development and feeding the system with their own work. One of the concerns with younger professionals, especially who didn't have experience in the field before AI started to blow up, is that they may not have the experience to recognize what issues may come up from, they may not be able to recognize with AI generated product what the problem is and be able to verify it as well. So while for more experienced architects may be hesitant to use the technology, we're kind of in a place where AI will likely be more helpful to more experienced architects that can recognize issues, and maybe kind of more of a problem with newer architects that might not recognize why the AI generated product is a problem. So that's something that we will go over more when we're talking about best practices, but it's something to keep in mind. And at least as of March 2025, with only 8% of firms adopting and reporting to use AI in their practice, at that point in time, you're not going to be considered to fall below the standard of care by not using it, because that's not what most architects are doing. And if you do use AI, and that differs from what most people are doing, and you fail to properly verify your work, fail to properly put it through the appropriate quality assurance, that will fall below the standard of care. Since the March 2025 study, the AIA AI Task Force has released 2 resources concerning the use of AI. So these came out in January 2026. And the first resource is the AIA Position Statement on Artificial Intelligence. So the AIA's official position statement is that the AIA believes that artificial intelligence is a transformative force that will reshape the future of architecture and architectural practice. AIA is committed to helping the profession navigate AI's evolution in ways that uphold architectural values, protect the public interest, and strengthen the profession's future. As this technology rapidly evolves, architects must remain curious, optimistic, and proactive in exploring how AI can enhance their work and elevate the built environment. The AIA encourages all members to thoughtfully explore and engage with AI as a powerful tool that can amplify design excellence, improve sustainability, streamline project delivery, increase building safety, facilitate design-focused research, and create more resilient and equitable communities. There are ethical, legal, and environmental complexities associated with AI, including concerns around environmental impact, authorship, data privacy, workforce transformation. Importantly, experts note multiple possible impacts on the profession. Some foresee greater disruption for managers who fail to adapt and warn of risks to early career architects if firms do not redesign pathways for mentorship and development. The association sees these challenges as best addressed through thoughtful leadership, inclusive dialogue, and responsible oversight. So the AIA's position statement is endorsing the use of AI as a tool to enhance efficiency, provided that it's being used responsibly and with caution. And we'll go over the guidance that the AIA has come out with for the responsible use of AI shortly. But the takeaway here is that now that AIA has come out with a protocol on the use of AI that's encouraging the use of AI, that's a signal that the standard of care is moving towards adopting the use of AI, and that failure to start implementing it and using it could cause you to fall behind the standard of care. As the use of AI becomes more and more prevalent, it's going to be critical to stay on top of how other firms are using it to improve their efficiency, to make sure that you are not falling behind. There's currently no laws in place that explicitly govern the use of AI in the field of architecture, but AI still needs to align with existing professional standards and licensing requirements. AI is not a human replacement, and while it can make your practice more efficient, it cannot substitute professional judgment. AI is tools, but it doesn't substitute for expertise and accountability. AI is not stamping plans. You are. So you're responsible for making sure that the information that you're getting from AI is accurate. Another kind of interesting thing to think about in terms of AI and its impact on the professional standard of care is not just that in order to keep up with the standard of care, you need to make sure that you are keeping up with what others are doing. But there is a potential for, with AI, allowing you to spend less time on data analysis and more time on critical thinking. That increased focus on critical thinking could further evolve the standard of care for architects. We also don't have any case law yet addressing design professionals' use of AI, but there is a question of whether or not the design professionals' use of AI would satisfy the professional standard of care can still kind of be assessed under the existing framework. As April went over with you, the jury instructions and the requirement to consult with a licensed professional in your field really shows that the question of whether the professional standard of care is satisfied isn't just an easy test. It's really, your favorite response from lawyers going to depend on the circumstances. So some issues that courts will look at in assessing whether or not the use of AI satisfy the standard of care are going to be things like, was the use of AI reasonable under the circumstances? Did it conform with any standards, guidelines, or professional prevailing practices that were in place at the time of the alleged breach? How did the use of AI compare to how other design professionals are performing at the same time and under similar circumstances? Was the reliance on the AI-generated product reasonable? What kind of program was being used? Is it reputable? Is it the same that other firms are using? What kind of data was it using in order to compile information? Did the design professional, especially as the art designer of record, exercise the appropriate oversight over the AI assignment? Did they perform proper quality assurance, and did they verify the AI-generated product? As we get busier, it can be tempting to just take things that look accurate, and especially with where we are right now, with how susceptible AI is to errors, never to just accept the accuracy of AI-generated materials. Courts will probably also look at whether there was any contract-specific requirements or project-specific requirements that explicitly govern the use of AI. I haven't seen that yet in any contracts explicitly stating, AI shall not be used, but we can anticipate that there will likely be clauses discussing the use of AI in future projects. And then finally, courts will likely look at whether or not the design professional complied with their firm's own internal guidelines, whether or not there were followed proper quality assurance procedures and verified the products. So now that I've gone through how AI can impact professional standard of care and be assessed in terms of liability exposure, April's going to go through AI exposure and best practices.
Thank you, Jessica. So before we get to the best practices, I want to first touch on the areas of exposure as it relates to AI and the practice of architecture. So the first one is, which has been mentioned here, is the substitution for critical thinking. As Jessica said, AI does not have professional judgment and is not stamping the plans. You guys are. And when you stamp those plans, it's not just a pretty stamp. You're taking responsible control of those plans and verifying that to the best of your ability, they're true and accurate. That's, so to the threat of AI in using it as a substitution for that critical thinking and that thought process and analysis and double checking is a significant area of concern and exposure. It also has the potential to result in a lack of creativity. If you rely on AI too much, you're going to risk all of the designs looking the same. That's going to hurt your business. That's going to make, it's not going to, your designs are what set you apart and what you're capable of, and what attracts clients to you. So the substitution for critical thinking and the overuse of AI is a significant risk to the practice of architecture. Another issue is hallucinations and false outcomes. I know you have all heard the stories of, AI making something up. And it's true. It is true and it is real. And, we've seen in the legal field stories where, an attorney will say, give me a case that says this. And the AI will spit it out and say, here's this case. That's what it says. But if you look up the case, it doesn't exist. The site doesn't exist. The premise in it doesn't exist. So AI is capable of hallucinating, and it has a tendency to completely fabricate outcomes and results. Another issue is the false outcomes related to the hallucinations and false outcomes is the analysis that goes in and out has a very significant impact on your result. So in this sense, AI answers the question that it is asked and not the question that you meant. So if the question is even remotely, tailored towards something else, or if it's not a clear and concise question, the answer can be completely different than the question that you thought you were asking. The failure to supervise is also a significant risk because there's essentially unfettered access to AI. Everybody has it on their phones, they have it on their computers. So when it's left, when there's no policies and there's no methods of acceptable uses, it's essentially an unfettered tool that you have that can't be vetted. And that creates competency issues as well as disclosure issues. I know Jessica mentioned that she has not seen contracts that specifically exclude the use of AI, but we are seeing a lot that include provisions regarding disclosure of the use of AI. So if you have that contractual provision saying, that you have an obligation to advise and or disclose if you've used AI in any sort of aspect of the project, then that can be a significant issue if the younger generation and those that are using it without being monitored and or advising that it's been used. Another huge concern is confidentiality. When you upload something to the internet, you need to know where it goes. You need to know what is the retention policy, what is the source, and where is it going to go? Where is it going? Where is your information going to be maintained? There are major confidentiality risks when you upload anything that could be a client product. Also internally, HR documents, you have trade secrets, you have all sorts of information that if uploaded to the wrong and or unvetted source can really disclose a lot of confidential information. Cyber attacks. We are also seeing a lot of cyber attacks these days. And this first statistic actually really, it baffles me. 80% of ransomware attacks are powered by AI. Not only is that, significant and huge because that's a lot of AI, a lot of attacks coming from AI, but it's also significant because that's also the source that we're relying upon, in the previous slide that we just mentioned, where, you're putting a question in and out. This engine is essentially intending to, it's completing a task. That is simply it. So, 80% of the ransomware attacks are on us. And then we're turning around and saying, uploading photos and uploading all sorts of information. So it's really important to be aware of what you are doing with your information and where those that you work with and for are doing with the information. Hackers are using AI to make recognizing spam increasingly difficult. I always thought, oh, our system is like Fort Knox, we're fine. But wow, AI is getting very, very complex, and AI is very, very smart. The first thing that we are seeing a lot of is AI powered phishing and spear phishing. And what this is attackers use generative AI to create hyper personalized context that's capable of phishing emails in seconds. So think of, for example, a personal email address with one letter off, or combining two letters so it looks the same. And they become familiar with the communications and the relationships, and they target those specific mailboxes. So Jessica could receive an email from me that looks just like my name, and it could come from a very similar, it'll just have one different letter, or even, one number, or a period or something within it. And it'll target her based upon her communications with me and alter my identity to make it appear as it really is me. Deep fake impersonation is, this one is so disturbing. So deep fake impersonation is where AI takes essentially clones voices, and generates video to impersonate executives and colleagues. So what AI does in this sense is it takes, that photo that I uploaded to ChatGPT and said, put a Christmas tree behind this photo and send it out as a Christmas photo, something like that. It takes that photo and then creates an image of my face, and then puts that elsewhere. So it looks as though it's a live video of me making a demand or a request or something for, typically for finances, but it's also being used for information and things like that. So that's a scary one. Polymorphic malware. So polymorphic malware is AI generated malware that adopts to the code structures that are within and embedded in your prevention systems, and it takes those code structures and morphs them in real time so that they can evade detection. And then AI enhanced reconnaissance and exploitation. This one is where these automated agents, it's constantly scanning your network and your infrastructure at a very high and constant speed, and it identifies any sort of vulnerabilities and is capable of deploying a malware attack within minutes. So if you have some sort of, system reset, or the system reboots once a month on X date, this software can scan and recognize that and attack at the perfect moment at that time of vulnerability. Data poisoning and adversarial AI. This is when attackers target AI systems by corrupting the training data sets with wrong and malicious data. What this does is it causes some AI models to produce incorrect, harmful, or insecure outputs. So it essentially, it poisons an entire AI platform to put out completely falsified information. So, and another big concern for the field of architecture is the impact on your copyright. Your copyright is yours unless you contract that away. It doesn't pass, just because you've completed the project. The copyright belongs to you unless and until it's contracted away. The issue is that a copywritten material can only be made of material that is the product of human creativity. So only something and only the segments of something that you've created may be copywritten. So, if you have and you can go to the next slide, Jessica. The next slide states that when you're submitting for your copyright application, you have a duty to disclose if you've used AI, and you have to give and if you have to give an explanation of your contributions to the work. So if you've used AI, you have to specifically declare and disclose, this is the part that I did, that I created, and this is the part that I used assistance with AI for. And only the part that you created fully on your own can be subject to copyright. So AIA's guidance for responsible AI use is they've published a list for the responsible use of AI. And the first thing is to maintain professional responsibility. I know this sounds like a no-brainer, but it's so important. AI is a design support tool. As you've heard all of us say, it is not a replacement for professional judgment. The architect remains accountable for all work product decisions and representations that were made to the client, to agencies, and the public, including work produced with AI assistance. And all AI generated outputs must be reviewed and validated by the qualified professionals. Establish firm level AI policies and oversight. So this means assigning clear responsibility for oversight of AI tools and output, as well as developing internal policies that address approved AI systems and use cases, data privacy and confidentiality protection, intellectual property management, ethical and legal standards, and to review and update these policies regularly as AI tools evolve. Protect data, privacy, and intellectual property. This means, again, do not upload confidential client or firm data into unvetted AI systems. Understand how external AI platforms store, reuse, or train on uploaded information. Clarify IP ownership for AI-generated content by reviewing terms of service and contracts, and consult legal counsel as needed. Address transparency, bias, and equity. Disclose to clients and stakeholders when and how AI is being used in project workflows. Ensure AI tools are evaluated for bias, especially in data sets and that are used to train models, to avoid reinforcing inequity through design outcomes. Design firm procedures to review and correct inappropriate or biased outputs. So, designate firm procedures so that there is a specific way that everybody knows this is how we go about reviewing, and this is how we go about correcting and identifying these inaccurate, inappropriate, and or biased outputs that are coming. Invest in AI literacy and staff training. Promote continuous learning across staff to foster responsibility and effective use of AI. Provide training on prompt creation and guidance. Again, this emphasis on AI answers only the question asked, not the one meant. So it seems like it would be, it seems like a no-brainer, but the prompt creation really drastically impacts the output. So invest in training on proper and inadequate prompt inputs. Ethics and accountability in workflows, and understanding AI application limits and appropriate uses. Encourage a mindset of experimentation combined with professional oversight. Collaborate and share learning. This also ties into the standard of care that we discussed earlier. Engage with AIA's AI education to stay informed and connect with your peers. Share both successes and failures to accelerate peer learning and industry standards. Partner across disciplines, engineers, technologists, contractors, to shape practical, interdisciplinary uses of AI in design and delivery. Defend the economic value of architectural work. This is how you make yourselves irreplaceable by AI. Encourage firms to move from purely time-based billing model toward value-based pricing model to ensure that AI-driven efficiencies strengthen firm economics. Define pricing and engagement around outcomes, impact, and expertise rather than hours expended. Examples include continuous client advisory, outcome-based services, participatory design platforms, and AI-augmented sustainability consulting. Incorporate AI adoption into broader business strategy and financial planning to preserve and grow firm margins. Expand ecosystem responsibility. What this means is to establish expectations for sub-consultants regarding AI use, including the disclosure of AI-assisted outputs. So as we mentioned earlier, as important as it was to be aware of your contract language regarding AI use, you can pass that down and require the same of your consultants so that you can also comply with your contractual obligations. Prepare strategies for working with or alongside client-deployed AI systems and ensure architects retain appropriate professional authority. And last but not least, policy and advocacy. The AIA National and Components to monitor and respond to emerging AI legislation, ensuring architects' interests are represented at the federal, state, and local levels. Encourage architects to engage with local components and state-level policy processes where AI governance is advancing rapidly. Advocate to protect the professional scope and value of architectural services in an AI-driven marketplace. So the takeaways are: tariffs create uncertainty. It's undoubtedly we're in uncharted territory, and there's uncertainty associated with that. So it's more important than ever to be diligent and proactive in how you go about your projects and your contracts. Use clear contract terms to limit your exposure to tariff-related risks. Communicate your anticipated concerns and take advantage of the technology available to you. AI is novel, but the impact of developing technology on a standard of care is an old concept. AI may enhance efficiency, but is not a substitute for professional judgment. Every firm should have AI training and policy.
All right, I think we have time for some questions.
You do have questions in chat. The first one I'm going to ask, then I'll let you take a look at them. So everybody knows, I put it in chat, but you may not have looked. This is being recorded and it will be placed on the AIA Orange County YouTube channel sometime next week so that you can see it or share it with others. Thank you, Jessica and April, for allowing this. Somebody wanted to know, will a copy of this presentation be available, like a PDF copy?
I can circulate it to you, Jeff, or
Yeah.
if that's probably the best way to do it.
Yeah, if you want to, yeah, when you have a chance, you can send it on over to me. And anyone here that's attending, if you want a copy, please email me, jgill@aiaoc.org, jgill@aiaoc.org, and I can get that over to you once it's available. So then there are some other ones. Would you like me to read these to you?
Sure. Let me see if actually stopping the screen share, I can see the chat as well. Yeah.
I have them. I can see them in the chat too.
There's a couple.
Yeah. We'll be able to get a copy of this presentation. So Andrew F. first asks, would the standard of care still consider project type? For example, a residential architect being sued because a healthcare architect thought the effort substandard. Jessica, I'll take a stab first and you can add what you want. But so as an initial matter, I think this question actually popped up when I was discussing the certificate of merit. So as it relates to the certificate of merit, no, it would not need to be specific to the area, meaning it would not require a residential architect. A healthcare architect could give an opinion as it relates to the residential architect services in order for the certificate of merit to be filed. Separate and aside from that, in applying the actual standard of care, the standard of care is that of a design professional in a similarly situated circumstance. So yes, the answer is that a residential architect that is sued will be held against the standard of care of other similar residential architects in the similar situation, provided you're working on a residential project.
Sometimes, just to add to what April said, a lot of times people have the experts that they like working with. And so there is a lot of issues where it's the expert, maybe a licensed architect, but they're not specifically familiar with that kind of project. And then it really just comes down to the judge's discretion. The person opposing the expert's going to say, look, they don't do residential, they only do healthcare. They lack a foundational basis to offer a standard of care opinion for a residential architect. And then the other side will point to some kind of anything tangential to a residential project. And then it's really going to turn on the judge. But honestly, it's pretty common to have your standard of care expert be in sort of an expert in a different project area than the one that is in the project, because it's hard to find an absolute perfect expert.
And then Andrew's next comment is about copyright. And he says that is a very different definition of copyright from what I understand it to be. Copyright is established when I print tangible medium, the drawings, and the term copyright appears next to my firm or practitioner name in the year. I've never had to apply for a copyright. So you're correct that the copyright is established at the time. The time is the tangible medium is printed. The copywritten materials can only be what you created as the human. You cannot have the AI or any sort of I think we could put the definition of human is within the copyright language. So anything generated outside of that definition of human cannot be subject to a copyright. It comes up in the sense of, is this copywritten when you have a copyright infringement or there's claims of an improper copyright? I think, does that answer your question a little bit? Okay, let us know if there's something else we can touch on that. Let's see. The next one is, how does the fair use doctrine apply with training and copyrighted data? Jessica, did you discuss the fair use doctrine?
I think that's specific to copyright, I believe. And I honestly, a copyright is a little bit out of April and I's wheelhouse generally, other than, it's something to be aware of and be cognizant of as you're using AI, because it can potentially take away from what could otherwise be copyrighted material if it's too much AI generated product.
And we do have a hand up. Barham has had his hand up for a little while. Barham, do you want to come off mute and ask your question?
Thank you. My question is, I remember the certificate of merit was in place for a long time, but anybody could act as an expert, and the lawsuit has been filed. You were saying that you have to be an AIA member or an architect member to become an expert, but I've seen that a lot of experts have written certificate of merit with that not qualified. By that time, if lawsuit has been filed, the battles are starting, and that I try to remedy this when I was at the Structural Engineers Association of Southern Cal, but I didn't get any traction to kind of have certificate of merit address this expertise of the person before filing, but never got there. But if you could enlighten us on this issue, I would appreciate it. Thank you.
Sure. Yeah, you aren't required to be a member of AIA, but you do have to be a licensed professional in the same practice. But one of the issues with the certificate of merit requirement is when you file it, you're not required to disclose who the expert is that you consulted with. It's not until the case is over and you win, and then you can ask the court to order the other side to establish that they actually did what they claimed in the declaration and consulted with the appropriate expert, that you get to find out if they did so. And if they failed to or they failed to consult with the appropriate expert, then you can actually recover your attorney's fees, which normally, unless there's a contractual prevailing parties attorney's fees provision, you don't get your attorney's fees, even if you're successful in defending the case.
I think there's a problem with the law. I think somebody's got to fix this. Thank you.
Yeah.
Yeah, so there's actually legislation being pushed by ACEC right now, which is, the Engineering Council, but they're working on legislation, and we've been assisting them in putting it where it tailors the language and the requirements for the certificate of merit requirements. And I agree with you. It has gotten to not serve the purpose that I think it originally was intended for.
Thank you. Thank you very much.
Let's see.
And there is another question in chat.
I think that it would be very difficult to separate out what appears in construction documents from a designer
Designer.
What?
From the designer?
Oh, designer versus, I thought maybe it was an AI platform. Designer versus the AI tool. I would expect that anything AI assisted and was still considered by the AIOR, and the act of stamping means the architect is in responsible control whether some portion of the design was designed by others and whether any of the persons involved used AI as an assistive tool. So incorrect to the extent that if you stamp the plans, that overrides any use of AI as it relates to copyright. Only human products can be copywritten. So the stamping of you can't print something on one of these AI platforms and then stamp it and then say, now it's copywritten based upon my stamp. So the requirement for it to be copywritten, and you have to specify this part was human created, whereas this part was used for AI assistance. So that would be the portion that you would be subject to the copyright, provided there was a challenge to it. Did you have anything to add on that, Jessica, or did I miss that question? Okay.
No, Does anybody have any other questions?
I'm not seeing any hands raised. Wait a minute. Oh, nope, that's a thank you. Oh, well, let's see what it says. That's a thank you.
Thank you.
Yeah, it was an excellent presentation. Thank you so much. I sure hope you're doing something like this at AI 26 in San Diego. I mean, it's just down the street from us.
We can talk about it, Jeff.
Whatever I can do to help out.
Likewise.
If not 26, then 27, because this is so important to the industry. And, I'm always surprised because my whole life has not been executive director of an AIA. It has been an architect running firms. And I'm shocked when I would see particularly large firms and how onerous their contracts were, to the point I would modify them because it just wasn't protecting the firm. And that was a long time ago. So we are so much more complicated now than we were 15 years ago.
Absolutely. And
Yeah.
and one of the arguments I think Bahram mentioned, with the certificate of merit issue is that it was originally intended to thwart these frivolous lawsuits against design professionals, and now it's become such an easy and unfettered process that it's not preventing frivolous lawsuits any further. And to the contrary, with the reporting requirements, it's actually forcing design professionals into settlements to, avoid reporting requirements or to avoid, significant exposure. It's forcing them into frivolous settlements, essentially, which increases the insurance premiums. It has so many more effects than most people think and or realize.
Well, thank you. We are at 5:29. We still have a minute for another question.
I was going to
I
say, we said we'd get you out of here by 5:30 and it's 5:29. So
If you scroll back, I did put Jessica and April's emails in there. You can always reach out to me if you missed it. I will get you in contact with them.
All right, well, thanks, Jeff, and thanks, everyone.
Of
yes,
course,
thanks
thank you.
everyone.